you are Douglas Ray Main Jr., is that correct?
Yes.
Mr. Main, if you'll raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. All right, Mr. Main, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes.
Do you understand everything that you've read and signed in your plea agreement?
Yes.
Do you have any questions? Mr. Manning, do you believe your client to be competent to enter into this agreement? If so, that he's doing so intentionally, knowingly, and voluntarily after understanding his legal rights?
Judge, he is competent, and I believe he's entering his plea intentionally, knowingly, and voluntarily.
All right, Mr. Main, you are charged by indictment in cause number CR 26-3 with the state jail felony offense of theft of property greater than $2,500, less than $30,000. State jail felony is punishable by no less than 6 months confinement in a state jail prison in no more than 2 years, and a fine up to $10,000. I see the plea agreement in your case is upon you pleading guilty. The state is recommending that your punishment be assessed at 2 years confinement in state jail, a $1,000 fine, plus court costs of $290 and reimbursement fees of $20. And the state is asking the court to dismiss DA 2024-1165, which is an evading arrest or detention with a vehicle. Mr. Manning, how much credit time would your client receive?
Judge, he has 178 days credit, and I may note, Judge, that there's also a motion to dismiss in both counts of CR 26-2. So count 1 and 2 of CR 26-2 are also being dismissed as a part of this plea agreement.
I don't see it as part of the plea agreement formally, but I do see the motions to dismiss followed by the state, but they're not included in the plea bargain portion of the judgment in CR 26-3. But for the record, the state has filed a motion to dismiss clause number CR 26-2 with regards to counts 1, 3, counts 1 and 3. Is that your understanding? All right, actually it says count 2 and then count 1, and then, yeah, count 3. So all 3 counts. It says CR 26-3, CR 26-2 star 1, CR 26-2 star 2.
Judge, my understanding, it was only 2 counts in that indictment.
Yes, Your Honor, there should have been 2 counts in CR 26-2 and pleading here.
Here in 3. Okay.
Yes.
Yeah, so pleading in 3 and then dismissing counts 1 and 2.
Yes, Judge.
CR 26-2. Are there any other counts remaining in that CR 26?
No, Your Honor, that completes that indictment.
Okay. So the court does note again for the record the state's motion to dismiss in cause number CR 26-2 counts 1 and 2. All right, so Mr. Main, that's your understanding of the plea agreement, what you're asking the court to accept?
Yes.
All right. So Mr. Main, at this time, I'd ask you, how do you plead to theft of property greater than $2,500, less than $30,000?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
Or it does accept the defendant's plea of guilt? Mr. Manning, any objection to the evidence?
No objection as offered.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just that in CR 26-2, no victim impact statement was returned, and in CR 26-3, no victim impact statement or restitution request was returned.
Thank you, Charlie. Anything from the defense?
Rest in close, Judge.
All right, court's reviewing the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. The court will follow the plea agreement. Court hereby convicts the defendant of state jail felony offense of theft of property greater than $2,500, less than $30,000. Assesses punishment at 2 years confinement. The state jail division of TDC orders the defendant to pay a $1,000 fine, court cost of $290, and reimbursement fees of $20. The court does dismiss unfiled DA case number DA 2024-1165, evading arrest or detention with a vehicle. court awards Mr. Main 178 days credit towards his sentence, time served in this cause. The court does grant the state's motion to dismiss in cause number CR 26-2 for both counts 1 and 2. All right, Mr. Main, you hereby remanded to the custody of the sheriff. We're going to take your fingerprint.
Judge, after review of the discovery, we have no contested pretrial issues. I do believe that there is a mitigating exculpatory statement that's been made. I have not been provided access to, but the DA's office did confirm they do have that, and we would be getting access to that. Additionally, Judge, we've been made an offer to resolve the case that involves SAFP as a condition of probation. However, my client has rejected that and requests to be set for jury selection.
All right, and what was the official offer or the complete offer?
Your Honor, we never got down to specifics, but it would have been a deferred probation with safety as a condition.
All right, so you want to go right to jury selection, Mr. Manning?
Judge, that is what Mr. Drummond requested.
And he understands that if he decides after today, he wants to take that deferred probation and go to safety, that the court can reject his request.
Judge, I don't remember if I specifically had that conversation with him today, but we have discussed previously the court's policy that once we get to, or once we get past announcing we're ready for trial, the court may or may not accept any additional negotiations.
You understand that, Mr. Drummond?
So,
Okay. All right, the court finds that Mr. Drummond, having requested jury trial, places him on the jury selection docket beginning May 4th. Once he gets into the top 10, Mr. Manning will notify you and Mr. Drummond.
thank you, Judge.
Since degree 1, a second degree felony that's set for arraignment. Go ahead.
Judge, on the CR 26 cause number, could you give me that last 3 digits?
It's 00028.
On the new offense, we will waive reading of the indictment. His name is spelled correctly. Enter a plea not guilty. Ask for a pretrial setting on that one. Now it's not ready on the MTR and ask those to be carried together for a pretrial on the new offense.
All right, court finds that Mr. Harrison has waived the formal requirements of arraignment, enters his plea of not guilty into the record in cause number CR 26-28. Court will set Mr. Harrison for pretrial hearing. On June, you want June 2nd or June 16th?
June 2nd, fine, Judge.
Court sets Mr. Harrison for June 2nd in each cause. Court will carry the motion to adjudicate with the new case.